Hello, and welcome to my Current Trends case brief presentation. Today we will be discussing the case that came before the Human Rights Tribunal of Ontario, entitled Winter v. Good Life Fitness. To begin, the full citation of this case is Winter v. Good Life Fitness, 2018 HRTO 252. Now, what are the facts of the case? This applicant believes they have been discriminated upon based on disability in regards to employment, a violation of Human Rights Code RSO 1990, Chapter 19. The applicant believes that she was stalked, harassed, and observed on many occasions. The applicant was formerly employed near Good Life Fitness and claims that on one occasion, two females came into the grocery store that she was working at. According to the applicant, the woman and her had a verbal altercation as a result of one of the women accusing her of romantic engagement with her partner. The second stalking incident occurred when she saw an unidentified Asian man reappear near her workplace after seeing him in another remote part of the city. The applicant decided to attend the Good Life gym that resided near her workplace, and chose to confront one of the unidentified individuals who she believed was stalking her. Security at the Good Life gym asked her to leave the premises, and the police later advised her that there was not enough evidence to rationalize and support an investigation. The applicant argues that there was discrimination in relation to social area of employment, as the stalking made her feel unsafe in her workplace and thus left her unemployed. She believes that she was discriminated upon due to the lack of action Good Life Fitness took to prevent the stalking from occurring. The respondent, however, was not her employer, which complicates her accusations, as the stalking did not occur in her workplace. Due to a lack of evidence, the application was dismissed. There are three core issues in this case. The first issue is a question of fact. Were any of the unidentified individuals employees of the respondent? If so, how did that affect the employment relationship, and was the employer at fault? Issue number 2 is a question of fact and law. Although the applicant has described two incidents that occurred in her workplace, are there allegations that directly bear on the employment relationship? The third issue is a question of law. Were there inactions of the employer that would violate the Human Rights Code? It is important to note that the counsel for the respondent is arguing that there was no ground for discrimination of employment, as the stalking events were separate from the employment relationship at the workplace. Meanwhile, the counsel for the applicant argues that the applicant had no choice but to leave the workplace because she felt unsafe in that part of the city due to a lack of safety ensured by her employer. The Human Rights Tribunal ultimately came to the decision to dismiss this application on the basis of a lack of facts to prove grounds of discrimination. You may be wondering what the rationale is for the conclusion of this case. I will go through each of the three issues and provide a rationale. For issue number 1, none of the unidentified individuals were employees of the respondent. Therefore, the altercation that occurred at Good Life Fitness was not the responsibility of the Good Life Fitness owner. For issue number 2 and 3, the applicant was not employed by the respondent, which means that there was little evidence given to suggest that employment at the grocery store was inhibited by the actions of the employer. Therefore, the applicant is accusing Good Life Fitness of harming her employment, and given the facts presented, this does not have enough to be proven. It is clear that there were not enough allegations of stalking at the applicant's place of work to conclude that the employment relationship was affected or that there were inactions of the employer. My personal beliefs on this case lean very far in favor of the decisions of the tribunal. After reading through the case, I am unable to identify tangible evidence to support the applicant's claims, and the applicant's application under employment discrimination does not seem to make logical sense. If the applicant was filing for grounds of discrimination with how the applicant was treated while at Good Life Fitness, perhaps by the security guards, then that would be an entirely different case. Evidence that was needed was proof that the employer had inactions that violate the Human Rights Code, and evidence that these inactions were due to discrimination and were the catalyst for the loss of the applicant's job. Without this evidence, I would also dismiss the case on the grounds of inadequate evidence. Winter v. Good Life Fitness shares many similarities to the case of Leduc v. Legal Aid Ontario, in which the applicant also filed an application under employment discrimination and a violation of the same Chapter 19 of the Human Rights Code. Both of these cases were dismissed on the grounds of inadequate evidence. However, a distinguishing factor is that Leduc argued discrimination based on ethnic origin, while Winter argued under disability. This case clearly shows the Human Rights Tribunal of Ontario's commitment to conclusions based on evidence, and that without adequate logic, reasoning, and support, a case shall be dismissed. I do not think that the rationale of this case reflects any implicit assumptions or implicit values, as the application was dismissed quickly solely due to a lack of facts. I hope that this presentation has helped you understand the case of Winter v. Good Life Fitness in a richer way. The survey question that I would now like to ask is, do you believe that the unidentified harassers should have been investigated for harassment of the applicant?